Thank you for joining us for Securities Law Compliance. My name is Raphael Zahardin. I'm at the law firm of Lewis Brisbois. I'm your moderator. As stated, this webinar is part of the Financial Poise webinar series, Inside Counsel Insider Corporate and Regulatory Compliance 1.0. We have included a slide deck. Please, you should understand from the get-go, we are not going to step through the PowerPoint. You're not going to have anyone reading slides. We're going to have a conversation with our panelists. But the slides are a great resource. Please download them. It'll encapsulate a lot of the information and issues we have here. That way you can just listen to us and not have to take extensive notes. Joining me today, speaking of our panelists, is Rakesh Gopalan of Troutman Pepper and Stephen Hinton of Bradley Arendt. We're lucky to have both of them here. We also understand that you're not spending your time and money to hear long-winded introductions about ourselves, but we are on the slides. Take a look at slides 73 to 75. You can get a little more information on us. Also, this webinar is production of Financial Poise. If you want to sign up for our weekly newsletter, go to financialpoise.com or shoot an email to info@financialpoise with the word subscribe in the subject line, and you'll get hooked up. If you're attending the live premiere of the webinar, you can submit questions using the web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Include your question and the name of the webinar episode, and we'll do our best to get you an answer. And we do follow up on those. This is going to be a quick hour, so oftentimes we don't have time to get to the individual questions, but we do follow up, and we're happy to hear them. One last note: we want to thank our sponsors, Mood Hardworking Cannabis, Type to Learn educational software, and Max Asset, which is an excellent online asset sale auction company. You can find out about these companies and their promotional products, both slides 3 and 4 and 76 to 77. So with those introductory remarks and thanking our sponsors and everything else, let's head right into this. So we're going to discuss the sources of federal security compliance, the effect of federal securities compliance on state law fiduciary duties, and how companies operate. Some guidance for board members in light of securities compliance, a discussion of independence, the impact of exchanges on the law here. We'll also discuss traditional SEC disclosure and the various documents filed with the SEC as they're the primary regulator. We'll discuss internal controls under Section 104. We'll talk about SOX compliance, both on public and private companies. And we'll talk about the way in which corporations operate and navigate this landscape of regulation, self-regulation, and formal regulation. Particularly how they interact, how companies will interact with their investors in the marketplace, and how state and federal law, pulls that all together. Though, like you said, there's a lot of self-regulation from important market participants, like the markets, like the exchanges themselves. So we'll cover all that in an hour, and you guys will be ready to talk to somebody about your securities compliance issues without a hitch. So why don't we start with Rakesh? Let's talk about we'll talk about the regulator. There's been a lot of rulemaking activity. This is an active SEC. Can you give us a highlight of some of the key areas?
Yes, indeed it is. Gary Gensler's rulemaking agenda has been moving along for the past several years. The most recent item of note would be the beneficial ownership reporting modernization, which was passed in October, the final rules were approved in October 2023. The new rules are effective this September 30th, 2024. It effectively reduced the filing deadlines for a number of large beneficial ownership reporting reports. It extended the deadline to file it to 10 p.m. on the specific deadline, but the initial filing deadline, for example, for qualified institutional investors and exempt investors is 45 days after a quarter end, as opposed to 45 days after the year end. And then there are different and lower, more different standards as it relates to 10% owners and other changes. For amendments, it remains triggered on material changes in prior information. And for qualified institutional investors and passive investors, upon exceeding 10% and any 5% increase or decrease. Again, the filing deadline for the amendment is 45 days after the quarter in which the material change occurred. Qualified institutional investors have 5 business days after the month end where ownership exceeds 10%. And there are a few other similar requirements. So I encourage you to, if you are managing or have a company or a client that is dealing with a lot of large beneficial ownership requirements in the way of 13Gs, then would definitely recommend looking into some of those detailed rules that have come about. The other items that have been recently implemented are the cybersecurity rules, which relate to disclosures in a Form 8K relating to material cybersecurity incidents, and as well as new disclosures in periodic reports. The share repurchase disclosure approved by the SEC has been invalidated by the Fifth Circuit, and so therefore the SEC vacated the rule. They're meaning that the existing and prior item 703 disclosure obligations remain. And then a couple other things that have been recently implemented relate to changes in 10b5-1 plans, including cooling off requirements, as well as clawback disclosures and new checkboxes on SEC forms.
Yeah, it's interesting because all this comes along with the Corporate Transparency Act that's also been passed, which requires more visibility into state law, with, I guess, the equivalent of beneficial ownership there too. And a lot of that's tied into the sanctions and the increased vigilance on money laundering and different conflicts, different places. Thank you very much. Stephen, can you introduce us to and distinguish between state law, particularly state law fiduciary duties, and federal law on the other hand, particularly Sarbanes-Oxley?
Yes, thanks, Raphael. So this is really to set the stage for the discussion today. Like many areas of law in the U.S., we have dual jurisdictions. So you have states that have their own sets of law, and then we have the federal government, which also has laws. When we talk about fiduciary duties today, we're going to be talking about the body of law that applies under state law to the officers and directors of a corporation that are intended to make sure that they act in the best interests of the company. So, for example, under Delaware law, the fiduciary duties of directors are most commonly sort of talked about in terms of the duty of loyalty and the duty of care, both of which are owed to the corporation. Those fiduciary duties can vary some from state to state, and can vary even more when you start talking about non-corporate entities like LLCs and limited partnerships. But generally, for today's discussion, we'll talk about corporate fiduciary duties. Those fiduciary duties are outside of many of the regulations that we're going to talk about with respect to securities disclosures under federal law. And so those laws are going to apply the same regardless of where the jurisdiction where a corporation is formed. When we talk about securities laws, just to run through some of the topics that we'll discuss today, the primary securities laws under the federal securities regime are the Securities Act of 1933 and the Securities Exchange Act of 1934. Securities Act of 1933 primarily deals with the sale of securities in the U.S. And the Exchange Act deals with a lot of different investor protections. But one of the big things that it does is creates a regime for corporations to provide disclosure to their shareholders, both financially and otherwise. And that's going to be a lot of what we talk about today. Of course, that was almost 100 years ago that those acts were adopted. There have been a lot of developments. Some of the more recent ones that'll be a big part of our discussion today include the Sarbanes-Oxley Act of 2002. It was adopted in response to a number of accounting scandals. And so a lot of the primary focus of the Sarbanes-Oxley Act, or SOX, as it's often called, are around making sure that financial statements are accurate and avoiding fraud, and making sure there's appropriate oversight, both at the board of directors level through an audit committee, it has to be independent, and we'll talk about independence requirements, but also at the management level to make sure that management puts in place appropriate steps to make sure financial statements are accurate. Moving forward, in 2012, the Dodd-Frank Wall Street Reform Act was adopted again in response to a crisis, this time the financial crisis of 2007 to 2009. It added additional disclosure requirements for publicly traded companies. A lot of those focused on compensation, but various other matters. And then there are a number of other sort of securities adjacent federal laws, things like the Sherman Act, Clayton Act, the Hart-Scott-Rodino Act. Those all deal with competition and apply even outside of publicly traded companies. But the key thing there is when we talk about this, you've got two different layers, and often you have to look at different issues and disclosure requirements, both under the lens of your state fiduciary duty requirements as an officer or director, but then also under the federal requirements about disclosure, independence, and the other topics we're going to talk about today.
So let's put this a little bit in the context. You were talking about these different controls. What's the effect on board governance? How's that evolved, and how is governance different from compliance?
Yeah, so governance, I would say, is really the framework that a company has in place to ensure that it's able to achieve compliance and then maintain compliance over time. And so when you think about just going through a checklist, like, okay, we have satisfied this legal requirement, that doesn't really answer how do you get to that point where you're in compliance. And a strong governance program is going to be the most likely way that you're going to be able to stay in compliance with a variety of legal requirements, also business, practices that you want to adopt to make sure you're having effective oversight of the business, as well as just managing risk in a general sense. And so that would be the difference, I would say, between compliance and governance.
So Stephen, then it sounds like you've got to have a firm grounding in a lot of different areas. So what does the board need to really, what needs to be the sweet spot in what areas for the board for them to effectively engage in sound governance?
Yeah, so that is right. Over the last 20 plus years, there has been an increasingly challenging environment from a risk management regulation standpoint for boards of directors, particularly of public companies. And so there's this idea of the past, a board of directors was a good old boys network. You had people on there who liked to play golf together. They probably knew a lot about the business, maybe not much about regulation. That worked fine. That's really not sufficient anymore, both to satisfy fiduciary duties under relevant state law, but also to make sure that you have the type of board that's going to result in compliance. So for example, recent trends in fiduciary duties, and talking most specifically about under Delaware law, since that's where the majority of corporations are formed, have seen a lot of focus on board oversight of risk management. And so that is, when you talk about risk management, it does involve understanding of the business, because you have to understand the business to understand the risk, but there's more than that. There's also regulatory and compliance risk, and those can be so-called mission critical risks to the company. And a failure for a board to oversee those risks could be a breach of the fiduciary duty of care. So that's been a trend in Delaware law recently, but also just more generally, boards of directors have moved away from just people who are collegial and happen to know each other to having both independent directors for a variety of reasons, but then also subject matter experts. You see a lot more people who have accounting backgrounds on board of directors, maybe other regulatory and compliance focuses, cybersecurity experience, even legal experience, seeing more attorneys that are becoming parts of board of directors. And part of that is because of all these regulatory issues we have to address. touched on some of them already. Financial reporting, audit committees are now required to have directors with specific areas of expertise. We're seeing a lot of focus on environmental, social, and governance matters, so ESG. And so companies now like to highlight the skills that their boards of directors have. So we see a lot more specialization and really more well-rounded and better functioning boards because of it.
And do you think ESG is waning, or do you think it's still a significant, force to be reckoned with out there?
Yes, I know ESG is a huge force to be reckoned with right now. Now, there have been some sort of publicized backlashes in areas of ESG, some places where companies are maybe moving away from some of the more aggressive, and then even responding to some potential liabilities that could be there. And so again, ESG, it's been a push for the last 10, 15 years to move beyond just financial considerations in the boardroom to the broader impacts that a company has on its community and its employees and society as a whole. And so there are a number of factors that get a lot of attention from proxy advisory firms, institutional investors, and then just the public at large that boards are having to navigate.
Thank you. Rakesh, what are some of the best practices that you found help to comply with the securities laws and regulations and rules that we've kind of touched on so far?
Yeah, and there are a few. I want to go back to one area that we're going to touch on, which is the in addition to the areas of law that Stephen mentioned, there are other areas of regulation that impact public company compliance, and probably the most important of which is NASDAQ and NYSE listing standards. And so we'll get into that later in this discussion. But those are the that's sort of the other element that throws in the independence of directors requirements, the audit committee requirements, specific independence for compensation committees, requirements that the board has a majority independent directors and all sorts of tests relating to it. And in addition, there's the PCAOB, which stands for the Public Company Accounting Oversight Board, which may not directly they do not directly regulate most of our clients and companies that you work for, but they do regulate the auditors who audit the financial statements. So a lot of times you will see certain methods employed by the auditors that directly relate to their own compliance with PCAOB auditor standards. And in addition, there are a set of internal control over financial reporting requirements that are a combination of certain requirements under SOX and other laws and best practices, as well as state laws and regulations. And those relate to whistleblower policies, codes of ethics, other legal compliance programs, insider trading policies, and things of that nature. But coming back to the question on best practice to comply with all of these different regulations, I would say there's a few factors that are really important. Number one is independence, and that can be in different ways. And it's not just your traditional board independence from management, but in various situations, making sure that there is, if appropriate, is an independent voice that can analyze the situation without regard to conflicts of interest. So that could be compensation related conflicts of interest. It could be job security related conflicts of interest, or anything along those lines. In addition, reliance on professional advice. And I'm not saying that just because that's what I do every day, but there are a number of professional advisors that are integral in order to perform and maintain your status as a public company. And that doesn't have to be external counsel like us. It can be internal counsel, because obviously internal legal departments have professional advice and often are really plugged in ways that we're not. But in any event, some combination of professional advice from lawyers, accountants, consultants are often very helpful. Lately, depending on the size of your company, you could be in the crosshairs of certain shareholder advisory groups that really where you really need to keep tabs on what those requirements are, and often compensation consultants can help advise as to what is the most shareholder friendly compensation package, for example, what bells and whistles are favored and what are not, in order to make sure that your election for directors every year is smooth and things of that nature. And then finally, I would say the other two things that come to mind are board evaluation and board education. And so in certain contexts, those are required. In other contexts, some companies decide to go further, but it's really, really important that you have a record that the board and different committees are assessing how well they're practicing, how big, what's the size of the board that's appropriate, what is the makeup of the board that's appropriate, and whether everyone has the prior skill set to be useful as a whole to the company, as well as whether they need to have continuing education on updated SEC topics and the latest laws.
Yeah, and there's been I think there's been a focus with a lot of the fraud scandals coming out of FTX and other places. I mean, I represent general counsel of FTX, and the issue of reliance on professional advice has been key in that in that fraud case. And there's been other cases like it, whether it's the Celsius case or others, where that's been a big issue. Stephen, where does independence come into play in corporate governance, and how does the SEC govern the issue of independence? Let's drill down on that issue, because I think it's an important aspect of I think modern boards.
Yeah. So at its most basic level, independence relates back to the fiduciary duties of a board. So the board's role is that of oversight. They are not the managers of the company. But there is this idea that to have effective oversight, the board shouldn't be beholden to members of management who have different interests and often have personal interests. And so, we see areas where independence under a state law fiduciary duty standpoint comes up in terms of a lot of transactions, where you may have an M&A transaction, and questions about whether it was approved by disinterested directors can affect the analysis. The SEC, though, applies its own independence criteria to a number of situations. And so, for example, the SEC adopted independence requirements for audit committee members following the accounting scandals of the early 2000s. The SEC also has rules about independence of members of compensation committees. And so the SEC rules themselves will have things that say, if you're going to be a member of the audit committee, you cannot be a member of management, because if you're a member of management, you are creating the financial statements. And we want someone else to be overseeing the audit of those. And so that's how the SEC rules can apply in addition to the state law requirements.
Yeah. And Rakesh, what about, let's go back to your point on the exchanges. In particular, how do they play a role in independence, and how do their standards compare to the SEC definition of independence? Or are there comparisons worthy of note?
Yeah, so they are much more robust and specific as it relates to independence requirements. And so we'll talk about I'll kind of go through the primary core elements of the independence requirements, which are pretty similar between the NYSE and NASDAQ. But the key thing to remember here is that when we talk about an independent board, it's independent from management, not necessarily from stock ownership. And in fact, the idea is that you want to be independent. You want those directors to be independent from management so that they're aligned with stockholders. Now, there's a point at which, under the rules and under governance policies and practices, there's so much stock ownership by directors that it could call into question that director's independence. But generally speaking, it's independence from management. There are specific requirements under the exchange rules relating to audit committee independence requirements. For example, not being a current partner or employee of an auditor of the company, making sure that there are no other entanglements between family members of the board member, as well as and the auditors. And in addition, there's compensation and business relationships that are prohibited. So, for example, there can't be a thing called compensation committee interlocks, where a director of company A or an immediate family member is an executive officer of company B, and an executive company A sits on the compensation committee of company B. So basically, that you're not doing each other favors because one person is setting somebody else's comp, and vice versa. In addition, there are requirements relating to significant business relationships in the past 3 years, payments to a company that is owned or controlled by a director. So related party transactions, above a certain threshold, in the case of the NYSE, is the greater of 1 million or 2% of a company's consolidated gross revenue, where the director is an employee or certain family relationships with that company. There's a charitable relationship as well component that often isn't automatically disqualifying, but needs to be disclosed on a company's website or in a proxy statement. And in that case, and in all cases, the board must weigh all of these factors to ensure that even if they don't fall within the prohibited categories, that they overall believe that the director does not have any relationship with the company that would impair their ability to make an independent judgment or decision about the company. In addition, there are, as I mentioned earlier, there are specific requirements for committee independence, so compensation committee independence from, as well as audit committee independence. And those really tie to the specific roles that directors play on those committees. So whereas if you're a board of director, you're on the board and you're not on the audit and compensation committee, for example, you need to be generally independent under the standards I mentioned earlier. But if you're a member of the audit committee, in addition, you need to make sure that you don't accept any directly or indirectly any consulting advisory or compensatory fee other than what you're getting as a board and audit committee member. It's because they don't want those who are employees or consultants of the company to also be the sort of independent audit committee. There are other requirements related to if a member serves on more than 3 public company audit committees, then the board has to make a separate determination that the director effectively has enough time to devote to the audit committee. The NASDAQ definition is substantially the same. I think a couple of the key differences that people look at is that they don't have the significant business relationship test that I mentioned, and some of the charitable contribution and relationship tests are different.
Okay, thank you. That's a fascinating. A lot of people don't realize the restrictions are a lot. I mean, independence from the exchanges is very different from independence in other contexts, particularly state law. Stephen, so everyone, even if you know nothing about securities law and compliance, you know that the SEC has a lot of disclosures they're mandated, and that's one of the key ways that the companies are reviewed by the SEC, and it is a big deal in terms of time, energy, and money for the companies to comply with SEC review. Let's focus on some of the documents that the SEC reviews, and let's focus on shareholder communications. So, what does the SEC review? What are the biggest issues related to shareholder communications? Just tell us why are these shareholder communications so important, and why does the SEC care?
Yes. Okay. So going all the way back to the adoption of the 33 and 34 acts, all along the federal securities regulation regime has been focused on disclosure. And that disclosure is meant to benefit investors so that they're not investing in things that they're not able to understand. So one of probably the key communication to investors every year is the annual shareholder meeting proxy statement, which also has to be accompanied with a copy of the company's annual report. It has to be provided to all shareholders. There were rules adopted several years back now that allow electronic provision of those documents with the notice being sent to them. But basically, so when we talk about a proxy statement, Annual meetings of shareholders are increasingly held virtually now, but even when they were held in person, shareholders didn't have to attend. That would be burdensome for many shareholders. And so they're able to submit a proxy, which is just a piece of paper that they sign and say, yes, I want to vote this way, and I'll nominate these people to cast my vote for me. And so under both state law and then federal SEC regulations, to get that vote, it needs to be informed. And so the primary document that informs investors when they're making those votes is the proxy statement. It has to be mailed out before a company can ask a shareholder for their proxy to vote at the annual meeting. And so those proxy statements, they cover a lot of the topics we've already discussed about director independence, and they have to be filed with the SEC before being sent to shareholders. They're subject to SEC review, but for a routine meeting, you actually don't have to file it in a preliminary form for the SEC to review it. Routine matters would include the election of directors, the approval of auditors, and voting on adopting compensation plans or shareholder proposals, some of the compensation votes, say on pay and things like that. The idea is the SEC is unlikely to comment on those, so companies don't have to file them in preliminary form. And often, even when a proxy statement does need to be filed in preliminary form for a charter amendment or something like that, the SEC will not comment. They're then sent to shareholders or are made available online, and a notice gets sent to shareholders. The annual report goes with it, and that's an opportunity for companies to really put their best face before shareholders. Sometimes you see those printed up on fancy paper called a glossy annual report. It generally includes the company's 10K, or at least most of the information that was in the 10K, and we'll talk about actually probably annual report on Form 10K. We'll talk about that some more. But there are a number of timing requirements that apply to the proxy statement and the annual meeting, and it circles back around and intersects a lot with state corporate law, because there are deadlines for record dates, there are deadlines for mailing dates under federal securities laws. And so the proxy statement is a big production every year for companies to be able to reach out to their shareholders, but there are a lot of legal requirements that have to be met.
As a whole cottage industry, we've done this panel in the past, and have been joined by folks from Edelman. You know, major public relations firms are heavily involved in the proxy system, right? I mean, it's the proxy season's a big deal. Rakesh, again, we've got several other disclosure documents that are really more they're filed on a regular basis. Some are filed when bad things happen. Some are filed, in response to certain things. And people have probably heard about 10Ks, 10Qs, and 8Ks. Let's start with the 10K. Can you give us a foundation on what the 10K is? And could you also talk a little about the SEC's recent focus on ESG and AI matters? I can't get Siri to actually talk to me, so I think we're years away from Skynet taking over. But the AI is coming, right? So it's something that we hear about every day. Tell me a little bit about how the SEC is working on that.
Yeah, absolutely. So as it relates to the 10K itself, the timing for filing depends on the size of the company. Generally speaking, you have to file your annual report on Form 10K within 60 days after the fiscal year end if you're a large accelerated filer. So that means that the common stock held by non-affiliates is valued at $700 million or more, which is tested as of the end of your most recently completed second fiscal quarter. Using that same test, if the common stock held by non-affiliates is valued at 75 million or more, but less than 700 million as of the end of the second fiscal quarter, and the annual revenues are over $100 million, meaning you're not a small reporting company, then your deadline is 75 days after the fiscal year end, and you're considered an accelerated filer. For all other companies, the deadline is 90 days. And generally speaking, the 10K includes a variety of things in addition to what people might think it includes, which is the financial statements for the period ended as of the end of the year fiscal year. So that includes elements related to executive compensation, discussion of directors, certain governance matters, and those things can be incorporated, forward incorporated into the proxy statement, which means that you can file your 10K, even though it's technically required in that document. You can file it without that information as long as you promise to include and do actually include that information in the proxy statement before that's filed within 120 days after the fiscal year end. So that's sort of the nuts and bolts of some of the additional elements of the 10K. But really the focus is the financial statements that are included, what's called an MD&A, a management's discussion and analysis of the results of the quarter and the liquidity of the company, as well as a host of other disclosures relating to the company's business and other statutory requirements. But as you mentioned, there's been a heightened focus on ESG. We talked about that a little bit earlier. The chairman of the SEC has been giving a lot of presentations recently on greenwashing. So the idea of providing extra disclosures or extra rosy disclosures sometimes relating to a company's ESG efforts without providing sufficient context and risk factors relating to that. So ESG, the phrase actually stands for environmental, social, and governance matters, and that can mean a lot of different things. And those are, each one of those topics are quite broad. Generally speaking, the most recent thing that happened, as I mentioned earlier, was I think I might not have mentioned this at the outset, but the SEC adopted sweeping rules relating to the climate disclosures and risks. So that had been in the works for several years in proposed form. It was actually adopted in final form in March of 2024. And it related to disclosures of climate-related risks that have a material impact on a company, including disclosures of actual and potential material impacts of those identified risks, qualitative and quantitative descriptions of material expenditures, activities undertaken in the ESG space, board oversight, and others. Also required disclosure about direct greenhouse gas emissions, known as Scope 1 emissions, indirect emissions, known as Scope 2. Although, thankfully for many people at companies, and maybe not so for those who are advocating for this position, is the Scope 3 emission disclosure, which is one layer removed, was not included in the final rule in response to comments on the topic. As expected, it was immediately challenged in court and the Eighth Circuit, in the Eighth Circuit, and the SEC has subsequently stayed the rule. So, some are saying that is going to be resolved by the end of the calendar year in 2024, but sort of it remains to be seen. Similarly, the SEC has also been focused on AI washing. I guess they don't have too many other phrases for some of these disclosure practices that they don't like, but similarly, saying that everything is AI or saying that routine technology or processes are AI when they're really not AI, or trying to get credit for it when your company's really not in that space, is something the SEC is really focused on, again, in their mandate to ensure that there's no misleading disclosure for the public. And so I think that's those are the main topics related to the format of the 10K, as well as the new ESG and AI requirements.
Well, let me ask you something. What kind of obligations do CEOs and CFOs have with the 10K? And some of that was tied into some of the financial scandals that happened in the past, right?
That's right. That's right. So they have to sign certifications, Sarbanes-Oxley certifications. So the CEO and CFO of a company has to sign these certifications, effectively saying a number of things, but providing the assurance and the representation that there are no misstatements or material omissions in the documents. And those are required for 10Ks as well as every 10Q. And there are a couple sets of certifications, and some of those certifications do carry personal criminal penalties for violation of those of the items that are included in the certifications.
Yeah, so it ends up being not just financial disclosure, but also, a disclosure that shows that there are controls in place to
That's
make
right.
sure that people don't run away with your money if you're an investor. Stephen, let's talk about the 10Q. So how is a 10Q different from a 10K? And what
Yeah,
are the
so
deadlines and everything else that go along with that?
yeah, so the 10Q, that is the quarterly financial report that SEC registrants are required to file. So it's due within 40 days after quarter end for accelerated filers and large accelerated filers. So using the same definitions as with the 10K. All other filers have 45 days after quarter end to get their 10Q on file. And so the 10Q is required after the first, second, and third quarters, not after the fourth. The 10K takes care of that. And the 10Q is really intended to build on the 10K. And so there will be quarterly financial statements, but some of the disclosures will say things like, since the 10K was filed, there's been this, or there haven't been any changes in our risk factors or legal proceedings, things like that. So each 10Q is intended to be read alongside or in addition to the 10K, but it provides updated information. It provides summary notes to the financial statements, so they're not full notes. Each 10Q is reviewed by an independent auditor. It is not audited, so there's a different standard there. But it does include those Sarbanes-Oxley certifications by the CEO and CFO, just like with the 10K. And there are some other things that get disclosed besides the financial statements and the management's discussion and analysis, like in a 10K. There's required disclosure about stock repurchases. There's now disclosures required about senior executive and director use of Rule 10b5-1 trading plans. Legal proceedings often get disclosed in the 10Q, but it's generally a much shorter filing than a 10K.
Right. Yes. I mean, you think of a 10K as an annual report, and this one more of a periodic report. That all sounds great, right? That those are easy. Rakesh, let's talk about the harbinger of bad news. Let's talk about the 8K. So what happens with an 8K? Is it always bad news? What triggers it? What's it all about? And put that into context in comparison to the 10Qs and the 10Ks.
Yeah, it's definitely not always bad news. In fact, it could be very routine news or very consequential positive news. But the idea is that the securities regime requires annual reporting when the 10K is required. It requires quarterly reporting when the 10Qs are required to be filed. But the securities laws do not generally require any interim reports unless there's a specific 8K trigger. There's one sort of overarching consideration to that we'll get to at the end. But as a general matter, the 8K is only required to be filed if there's a specific triggering event. And there are many, some of which are broad and hard to determine. But so examples of those triggering events are entry into a material agreement, which again, often is a positive thing. Termination of a material agreement. And that includes certain executive compensation agreements with various exceptions, M&A deals, significant contracts, or outside of the ordinary course of business. Other triggers are bankruptcy, material cybersecurity events, financial developments, so earnings releases. So companies do not need to issue an earnings release outside of a 10Q. Many companies routinely do. If they do, then they have to file that document, file or furnish that document with an in the body of an 8K. There are other financial developments such as impairment of assets, triggering events for certain defaults, accounting developments like the modification of the termination of an auditor, for example, delisting notification from exchanges, issuances of securities and unregistered offerings, modifications of rights of security holders, changes of controls, departures of specified executives or directors, waivers of code of ethics, changes of articles or bylaws. And again, each one of these involves a determination, specific requirements, and there's a whole body of guidance related to what falls within or without these buckets. As an overarching deadline for filing these 8Ks, they're much sooner than the 10Qs and 10Ks, and they're 4 days within 4 business days of the triggering event. And that is the case for a number of the 8K requirements that relate to the triggering events.
And that's so the class action lawyers can get ready to go on as soon as they get the news, which seems to be a lot of what happens with cybersecurity issues, and that's why there's an uptick in books and records demands in Delaware Chancery Court, right? That's their pre-litigation discovery.
That's right, and I think the other point to note related to 8Ks is certainly there are consequences for failing to file timely your 10Ks and the 10Qs, and that may be obvious because those are the things that people think about. But failing to file on time a triggering event under an 8K can render you ineligible to use certain short form registration statements, for example, with the SEC and some other ramifications. So these deadlines and the triggering points are really important, and it's important for companies to establish disclosure controls and procedures and regimes to ensure that information that is happening all around, often large companies, is being monitored in a way with compliance, with legal, with finance, to ensure that there is or isn't a triggering event.
Awesome. So we're coming up on a little bit less than 15 minutes to finish up, but you guys have been great, and but we're going to get into an area that we could talk about for 4 hours if we needed to, right? Let's start with Stephen, and let's try to hone this down. So SOX implemented all kinds of internal control requirements under Section 404. What are internal controls? And tell us a little bit about Section 404.
Yeah. So when we talk about internal controls, this is essentially an accounting concept. It's incorporated into SEC disclosure requirements. But an internal control is any process, policy, procedure, anything that's put in place to ensure the reliability of the company's financial statements and related disclosures. And so when we think of some examples, it might be requiring that someone logs in to the company's computer system to prevent unauthorized access, which could be used to falsify financial records. Or it could be reconciling internal accounting information with some sort of external information like a bank statement. Internal controls are even so broad that they include things like physical security, like how you let people in and out of your building, and also cybersecurity. So it's the entire environment that is set up to make sure that, or ensure that, the company's financial statements are accurate and help to prevent fraud. And so we've referred several times to the significant accounting scandals of the early 2000s that resulted in the Sarbanes-Oxley Act. And one of the key provisions of SOX was Section 404 that established SEC federal securities law requirements around internal controls. So there are two sections, two clauses of SOX Section 404. So the first is 404A, and that is what requires those certifications and a disclosure in every 10K and 10Q that says management of the company, under the oversight of the company's CEO and CFO, have conducted an assessment of the effectiveness of the company's internal control over financial reporting, and then you have to give the results of that assessment. So it's either effective at a reasonable assurance level, or there's some sort of material weakness that may have been identified. And so there's a disclosure requirement and the requirement to do the assessment. And then secondly, there's SOX section 404B, which for certain companies requires that this review, this management assessment of internal control, also be audited by the independent auditor of the company. And so the independent auditor has to also attest that they have audited management's assessment of the effectiveness of internal control. So those two provisions in tandem are intended to ensure that internal control and the effectiveness of internal control gets attention at the highest levels of management, and that it also gets an independent inquiry from the auditor.
Yeah, when they were drafting Section 404 and SOX, the big issue, the big touch point, because of what happened with Enron and some of the other scandals, was where were the gatekeepers, right? And certain people, accountants in particular, and they were trying to also hold up general counsel and lawyers. But I've never seen a company where general counsel's running the show. General counsel's usually serving the board or other people. There's very few instances of the general counsel being the dominant party, or the party maybe that has access to everything. Usually they're trying to keep stuff from the general counsel because they have other obligations. But if there's a fraud situation, but yeah, 404 kind of ended up turning out a little bit different in the final drafts. Rakesh, SOX compliance is a big issue for the SEC. So who does it apply to? I think there's a conception this only applies to public companies. Is that accurate?
That's not. It's clearly the thrust of it, and the majority of what's in Sarbanes-Oxley and came out of Sarbanes-Oxley relates to public companies and disclosures for public companies. But Sarbanes-Oxley does apply to all companies for certain things, such as criminal liability for document destruction that impedes a federal investigation. SOX also included a securities. Sarbanes-Oxley for securities fraud was extended to 5 years for all companies, and debts incurred for violation of securities fraud laws are non-dischargeable in bankruptcy. So that's another thing that the Sarbanes-Oxley Act did. There's increased liabilities for white-collar crimes, as well as whistleblower liability provisions for retaliation that apply to private companies as well. And in some senses, at this point, for however many, nearly 25 years, or over 20 years after Sarbanes-Oxley is passed, some of those things are just sort of ingrained in the law, and so some people don't think of it necessarily as SOX compliance, but they are.
Thank you, Stephen. Smaller companies have had compliance, costs money, costs time. So some smaller companies have had trouble with compliance costs. How do small companies deal with that issue? And what types of companies are particularly vulnerable to that pressure under SOX?
Yeah. So especially companies that are private and looking to go public, or possibly being acquired by a publicly traded company, are facing having to step into those 404A and 404B requirements to test internal controls and get the audit possibly. So, there is a cost both internally to implementing, documenting, testing, and auditing your internal controls. But then when you bring in a third-party independent auditor, they're going to charge fees as well. And so there was an idea over time that these costs to the internal control requirements from SOX were burdensome for smaller companies. Private companies that were looking to possibly go public were in theory being turned off and choosing to stay private longer, in part because the increased compliance costs from these internal control obligations. So to ease that burden, in 2018, the SEC adopted an exception from the auditor attestation requirement under Section 404B for smaller reporting companies. So that's a definition of companies under SEC rules that have less than $100 million in annual revenues. And so the idea was, we're going to help out for public companies in general that are smaller, let them save some of the costs from having to pay their auditor from doing the audit of internal control assessment.
Okay, great, Stephen. I'm gonna end off. I'm gonna give you the last word, but I'll ask Rakesh to pipe in too if he wants. So we've talked about growth companies and a concern in terms of the compliance costs related to SOX. Was there any relief in any sort of legislation for those types of companies?
Yes, and so this dovetails well with the mention of smaller reporting companies having an exception. The Jumpstart Our Business Act was a law adopted in 2012, and it created an exemption from many disclosure requirements, also some scaled disclosure, so lower requirements for what are called emerging growth companies. And so emerging growth companies are companies that are within 5 years of their initial offering of securities, of equity securities that was registered with the SEC, that also have had less than $1.235 billion in annual revenue in their most recently completed fiscal year. So if a company meets those standards, and often that could be the case following an IPO, that company for up to 5 years would have these scaled disclosure requirements. And so, one of those exemptions is the exemption from having to get the independent audit of internal controls under SOX Section 404B. You can also have other scaled disclosures like around executive compensation, even the financial statement requirements in connection with the IPO, and also for the period of time they have to adopt new accounting standards. So a company that qualifies as an emerging growth company, or EGC, gets a lot of potential benefits from that in terms of cost savings and required disclosures. However, in addition to the 5-year limit, the 1.235 billion annual revenue, that's for the most recently completed fiscal year. And if you cross that before the 5 years, you lose your status. There are a couple of other ways as well, including if you issue over 1 billion in debt securities, or if a company becomes a large accelerated filer. But absent those things, the EGC status is helpful for many companies to avoid some costs.
That's great. Rakesh, you want to give us some last words?
I think that's right. But I think in addition, there are still a lot of compliance costs, obligations, requirements for public companies. And so having done many IPOs, I think that one of the things that's most important to remember is that in addition to the upfront cost, there's a pretty significant ongoing compliance cost for people like us and auditors and things of that nature. And so companies really need to figure out the reasons why they want to be public. And there's a lot of really good reasons in terms of access to public markets and things of that nature. But there are also some other not so great reasons, which is just that, some founders just want to be public company CEOs, period. And if the costs make sense, that's okay, but sometimes it doesn't. So I would say that there are eased burdens now, but it still remains a pretty hefty responsibility.
And do you ever see some of the disclosure that we're talking about? I mean, look, I know, for example, an annual report is really, on the nonprofit side, for example, is a way for it's a way to solicit more funds, for example. Is this all really just a burden, or is it an opportunity in some instances to be able to put out a pretty solid face to the world on things? And I know a lot of companies go back to being private because they don't want these costs, but is there an upshot for this in terms of accessing capital markets? Or
Absolutely. And that's where the benefit and burden discussion comes in, and the burden being the time and the resources and the excess transparency, the benefits being it's absolutely what, and whether or not you are trying to raise money off of the documents, from an investor relations standpoint, people use the 10K and proxy in particular as investor facing disclosure documents that are helpful to paint a picture as to what the company is doing and what it's going to do.
Yeah, it's one of the first tasks. I know a lot of my friends have become general counsel. It's one of the first tasks that they're given is the SEC compliance, because it's a really key thing for lawyers. Look, it's been a pleasure to speak to both you guys today. This is the conclusion of our webinar. Thanks for joining yet another great Financial Poise webinar. I hope everyone out there, both on demand later and during our live premiere, enjoyed the discussion. And as we discussed, send us something at info@financialpoise.com if you have further questions, or you want to carry on any, have any further inquiries or discussion with us. With that, that's the end of our webinar. Thank you.